Hello everyone, welcome to today's Legal 101. It's been a while since I've posted one of these. I think the last one was in mid-June. Now the reason for the hiatus was because first we lost Honorable Kivuti and therefore in solidarity with the judiciary, because as you will have noted, we use so much of what they have done, the judgments they have given, to create this platform. It was my version of a moment of silence. And then with that came also their intention to go on strike, where they indicated they wanted better working conditions, although that was quickly resolved. Although I'm not sure it's actually been resolved. And then came the Mandamanos. And so at that time it was imperative for me to read the room. You wouldn't easily talk about divorce or talk about family and children, even though they still remain a huge reality for people. But it's just that I wanted to make sure there was room for the discussion on the finance bill and the discontent with the manner in which the country is run. And right now it has slowed down a bit to give room to other things that we can discuss, but make no mistake, it is still an issue that is very live. And so I have decided to come back. I missed you, and thank you to everyone who has continued to show support, even sending a message on the DM saying I enjoy the platform. Yeah, that's amazing. I have also noted that the more views a video gets, the more exposure then that is, especially to people who haven't been here for a long time. And if somebody is just committed to misunderstanding what you're saying without understanding the history of this platform, they listen to react. They don't actually listen, which is tragic, because my aim here is for all of us to understand the trends, to understand, legally speaking, to understand legal positions of various things. That's my cat making a cameo, and that's really the goal. And it's fine if you have a different view. It's actually allowable, but the way you say it doesn't have to be disrespectful. Okay? And so for today we have Legal 101, which is on employment and labor relations law. Now, if you have an employment contract, I want you to see if it has an arbitration clause. An arbitration clause is a clause that says that if there is a dispute between the parties, the employer and the employee, then the first port of call is before an arbitrator, who will then determine the dispute between the parties. To help us understand this better, we are borrowing from a judgment that was actually a ruling that was delivered this year, May 2024, by Honorable Justice Jacob Gakeri. And these were the facts. So the claimant, whoever went to court first, was employed as the group chief executive on the 1st of June 2021. There was a written contract. And in the contract, there's a clause 6.2, which was an arbitration clause. Actually, it was a dispute resolution clause. And it said that if a dispute arose, the parties would first attempt to solve it by mediation. And if mediation failed, they would refer it to a single arbitrator jointly appointed by them. So the claimant had lost the claim before the employment court, and his employer moved to stay whatever proceedings were ongoing before the employment court, citing the provisions of the dispute resolution clause. And they said there's room for arbitration, and previously we've been sent to mediation, it hasn't worked. Shouldn't we follow what the contract then provides? I mean, no court has the power to rewrite a contract. If a contract provides for X, then the parties should follow X. Okay? That was their argument. And so the court had to ask itself, is it fair? And what is the legal provision that allows parties to go to arbitration in an employment matter? And why actually is arbitration important? Okay? We have many forms of alternative dispute resolution, but each of them differ in the way they are conducted, and the desired outcome is different for all of them. Okay? And so the court looked at Article 159 of the Constitution, which encourages parties to always consider alternative dispute resolution mechanisms, including arbitration. Section 12 of the Employment and Labor Relations Court Act. Now, under Section 12, it lists down various types of disputes that an employment court is supposed to handle. And actually the opening line for subsection 1 provides that that court has exclusive, original, and appellate jurisdiction to hear and determine all disputes relating to employment and labor relations. You've heard where I've made emphasis here: exclusive, original, and appellate jurisdiction. When you have exclusive power, it means you're the only person who can do certain things, right? When you have original power, it means you're the first person they come to when there's a dispute, right? The court also looked at section 15 of the same act, and it is the one that talks about alternative dispute resolution mechanisms when it comes to employment disputes. And it says that provision allows for internal methods of solving disputes. It allows for conciliation, it allows for mediation, it allows for traditional dispute resolution mechanism, but it is surprisingly silent on arbitration. So the court asked itself, is there a reason why Parliament omitted arbitration from the Employment and Labour Relations Act, knowing full well it is provided under the Constitution? Is there a reason? And I recently was tussling with somebody in the comments where I said sometimes some legislations are made and it is because the parliamentarians didn't think far enough to provide for a certain scenario within the document, and that is why people go to court and seek amendments. That is why legislations are amended, and sometimes they do it on purpose, okay? Because at the end of the day, we have seen the interests that drive so many parliamentarians who are our lawmakers, okay? The court said, I will consider a Supreme Court decision, and like you must be aware by now, Supreme Court decisions are binding upon all courts subordinate to it. Court of Appeal decisions are binding upon all courts subordinate to it. High Court decisions the same. So here we're before a High Court judge. So the court considered a Supreme Court decision which provided that there is no doubt that arbitration is an attractive way of solving commercial disputes, okay? By virtue of the perceived advantages it brings beyond what is generally offered by the normal court. And the normal court will have many formalities and therefore many delays. And as you can imagine, a judge has numerous files. But the court must still remain a guardian, a watchdog over what happens in arbitration. Since arbitral law was created to solve commercial disputes, then it is not the best place to solve an employment dispute. And you might want to ask yourself why. But I want you to go back to when you're signing an employment contract. At that moment, your motivators, most of the time, are on whether you're going to have your leave days, on how much you paid, what happens when you want to terminate. Very rarely do you pay attention to an arbitration or a dispute resolution clause. And it's because of how we are socialized. We don't think it's a partnership. We think it's a slave-master relationship. We think the employer has more bargaining power. It is just how we are socialized, and it is tragic, yes. But it's how it is. And how do our lawmakers ensure that there's some kind of balance? The omission of arbitration under the Employment and Labour Relations Court Act is very deliberate. Other methods can be explored, but not arbitration. And so the court said, I'm not going to give you stay. We're going to continue here in this route until you solve all your problems. And just to reiterate, I think I've said this before. The Employment Act may seem like it favors the employees more than it favors the employer. But for an employer, you need to shift your mindset. You need to look at it like this. If I am compliant, if I'm doing the right thing, if I lead with integrity, then I have fewer cases of non-compliance. But if you're forever being followed with minute cases of, oh, you terminated somebody without a disciplinary hearing, you did not provide somebody with sick leave, with annual leave, these are now your problems, things which already have been solved by there being a provision under the Employment Act, then you're your own enemy. I would say shift your mindset. Don't think like you're the victim. Comply and focus on the things that actually build the company. And as an employee, there are so many tools already at your disposal. Okay, that marks the end of today's Legal 101. It's great to be back. Please interact, ask questions if you want to. See you for tomorrow's Legal 101. Bye.